We will not be recognizing raised hands during the presentations, so please use the question option, and we'll then address the questions at the end of the presentations. Importantly, we will not, excuse me, we will not be discussing project specifics. When you have some input, you certainly, if you have in your mind a specific project where you think you have some ideas that would be beneficial for our development of rules, by certainly share them, but we don't want to get into details on specific projects. We have projects that may be in certain parts of an appeal process, and we just can't get into specifics. For those who do wish to speak, as Tom Taggart mentioned, please use your raised hand during that portion of this input session. We will recognize you. We ask that you limit your input to 2 minutes, so everyone will have a chance to speak, and certainly as time permits, we will come back to you. But as Tom O'Donovan said, we want to hear your ideas. That's the purpose of this session, to help us as we move forward in further rule development. Briefly, the agenda for today. As I said, I'll give you a little background on the Alteration of Terrain program and our current rules and the development of rules over the past few years. And then Chris Aslan from the Attorney General's office will provide some legal background and statutory authorities as they pertain to both alteration of terrain and to the New Hampshire Fish and Game Program or Fish and Game Department. And then 2 representatives from Fish and Game, Mike Marchand and Melissa Dobrowski, they will provide a presentation on their program. And then we've asked Marianne Tilton from the Wetlands Bureau. She's going to present a model approach that is something to consider, which basically discusses as a model of the thought of avoidance, minimization, and mitigation as an approach for T&E species and consideration of AoT permits. I think that should be helpful because that is a program that's gone through a lot of review, and it is currently within rule, and so it gives you an idea of some of the process that we'd have looking forward to develop such things in an AoT rule. And then after the presentations, we'll have a short time period to answer the questions that were submitted during the presentations. We'll then have a 15-minute break, and then we'll open it up to your input. So briefly, the program background for alteration of terrain. Our statutory authority was established in 1979. It's RSA 485A17, and subsequent to that authority, rules were first adopted in 1981. Now, the primary focus is on stormwater for large development projects. We look at how change in the landscape will affect stormwater runoff, and the permitting requirements address that from anywhere from sediment and erosion controls to peak flows. And as I said, the primary focus has been on stormwater. Today, we're obviously going to be talking about how those projects could impact threatened and endangered species and where the rules stand and where they could go towards enhancing those protections. I think it's important to note, because there has been, I think, through some public hearings we had while we were developing earlier rule, the one rule that's effective as of just June 2nd of this year, there's a little bit of a misconception of our authority, or at least the breadth of our authority. And it's limited to large development projects. It's 100,000 square feet in disturbance. There's some nuances to that. I don't think we need to get into that detail. But what shows is we currently receive about 200 permit applications per year. So it is not all projects of construction that you may see in your neighborhood, so to speak. So some other rules, or at least rules and or criteria that we look at regarding T&E species, I have up here on the screen. I am not going to run through them in any great detail, but basically what it says is any project application that comes in, there is initially some coordination with the Natural Heritage Bureau for checking their database to see if there's any reports or records of T&E species in the area. That being done, they will then receive a data check letter back from NHB, and up until our most recent rule, and I'll get into a teeny bit more detail, they'd either receive a letter that said there was nothing found in the vicinity and there was essentially no further action, or they had an assessment of potential impacts, i.e. records were found, and then we would coordinate further with Fish and Game personnel. There's one other rule that pertains to plan modifications, and this basically is saying that once an applicant has received a permit, if there's any modifications of the permit that require us to take a second look, we would then revisit with NHB because perhaps a project expansion could have additional effects, and so we would check with NHB in that manner. I also do want to note that the most recent, because we have had a memorandum of agreement between DES, NHB, and Fish and Game for many years. The most recent one was signed in 2017. And what that basically does is describe the responsibilities of the three agencies and our coordination. And I think most importantly to this discussion is it directs that DES will incorporate within permits recommendations of Fish and Game as they pertain to T&E species. So a brief history of our rules. The first rule that was specifically adopted to address this issue of T&E species was adopted in January of 2009. And you can see there that it's in ENV WQ 1503-19H. That citation has not changed. And at that point, and Chris Aslan in the next presentation will talk in a little more detail on this. But essentially what it said is, in order for us to issue a permit, the applicant had to demonstrate that the project was designed in a manner that will not result in adverse impacts to T&E species. That rule, once again, and Chris will touch a little bit more on this, was in effect until 2019. We had on a specific project an appeal that resulted in a decision or an order from the Supreme Court. And we determined as a department that we could not operate under that rule. So we adopted an emergency rule to allow us to continue forward in our responsibilities in reviewing permit applications, and adopted this emergency rule. And where the significant change was there is we did say that the project has been designed in a manner that will not jeopardize the continued existence of T&E species. So that rule was adopted in December 20th of 2019. It had an expiration date of mid-June or so. So we started working on a more permanent rule that we did have some public input through public hearings. The public identified some of their concerns with that. And so we did adopt a second rule, but I think the important thing, which is, resulted in where we are here today, is the department realizing that because of the limited time frame of the emergency rule, that we had to have a rule in place, but we just did not have the time to go through this public participation that we're having today. So the department committed to having this rule effort that we are at the beginning stages of with this input session. And based on information we gather through these sessions, we will then undergo another rulemaking process with the goal to have a new rule sometime in the early part of 2021. And so the rule that we did adopt to replace the emergency rule, you can see here. This is our current rule. And a significant change in this was we continued with the requirement that the project not be designed in a manner that would not jeopardize the continued existence of T&E species. But you can see within that paragraph, which I think was an important modification, based somewhat on what we had heard from the public, was that we wanted the applicant to demonstrate through a site study or survey with a wildlife biologist that they could demonstrate that the project was designed in a manner. And the reason for doing that was previously, the previous process, we relied on the NHB database, which is not necessarily fully encompassing all project sites throughout the state. So this would allow the department and Fish and Game to have additional information specific to the project. And so this was the rule that was developed and we're currently under, and the rule that we will now perhaps be replacing through the process that we're beginning today. So at this point, Tom, I think we can switch it over to Chris Aslan.
Okay, I'll share my screen here as well. Good afternoon, everyone. My name is Chris Aslan. As Rich said, I am an attorney at the Attorney General's Office. I represent Fish and Game and DES in various capacities. And what I'm going to do is present just briefly on the legal framework that we're operating under here in order to determine how rules can be developed. And if you bear with me for a second, I can get this up and running. Okay. Great. So again, Rich touched on some of the background, but what I want to emphasize here is just which statutes are in play, what the framework is in terms of the statutory scheme, and then also touch on the Supreme Court case that Rich mentioned as well that led to some of the rule changes that have happened in the last year or so. And there we go. So Rich mentioned RSA 45A17. That chapter of the state statutes is the Water Pollution and Waste Disposal Act. And that is where the AoT program resides. And the purpose of that act is to protect water supplies, to prevent pollution in surface and groundwaters, and to prevent nuisances and potential health hazards. So as you can see, it's a water pollution focused act. And the specific part of the act that deals with AoT program is RSA 45:17. And that is the part of the statute that requires applicants to obtain a permit from the department prior to terrain alteration that impedes the natural runoff or creates an unnatural runoff. And as Rich said, that doesn't apply to every single project. It's certain projects of a certain size or a certain impact. And with regard to the discussion we're having today, it's important to note that this act, the Water Pollution and Waste Disposal Act, doesn't address T&E species at all. There's no reference to them in the act. It's focused on water pollution. And that gets to the question of what authority DES has to implement rules about T&E. And so the part of the state statutes that deals with T&E is called the Endangered Species Conservation Act. That's RSA 212A. And the purpose of that act, among other things, is to protect threatened and endangered species. The language in the statute is as necessary to maintain and enhance their numbers. Under that act, there is a number of provisions, but relevant to what we're talking about is that the Fish and Game department and the executive director has authority to enforce a prohibition on the act of take, which is defined in another statute. But essentially, that's the part of the statutory scheme that says you cannot take threatened and endangered species or harming them. Conversely, the executive director also has the authority to permit what is normally a prohibited take for a variety of reasons. One of those is to enhance the propagation or survival of the affected species. And that's something that comes into play in a number of AoT projects where there are conservation measures imposed that will allow an applicant to move species, exclude them from a project area, etc., in order to protect them. And that falls under this provision. And so 212A is a fish and game statute, 45A is a DES statute. The confluence of those two comes in RSA 212A9, paragraph 3. And that's a part of the Endangered Species Conservation Act that requires all New Hampshire departments to assist and cooperate with the Fish and Game Department in furtherance of the protection of teeny species. And it has this language to the extent possible and consistent with their authorities and responsibilities. So it's a somewhat qualified cooperation. But specifically to the T&E, there's a requirement that DES and any other state department take such action as is reasonable and prudent to ensure that actions authorized, funded, or carried out by the department do not jeopardize the continued existence of T&E species. And then additional language about modification of habitat. And that's really the provision of the Endangered Species Conservation Act that brings DES into the picture, because an action that's authorized, funded, or carried out by would include permitting a project. And so when DES permits a project, it must do so in a way that does not jeopardize the continued existence of T&E species. That provision is really the only authority that gives DES specific authority to implement rules regarding T&E for the AoT program. And that's important because it's not something that comes out of 45A, it really comes out of 212A. And the statutory language of not jeopardizing the continued existence is the standard that DES is held to. That requirement under the statute has been implemented by DES by promulgating the rule that Rich was talking about a few minutes ago. That's ENV WQ 1503.19H. And part of that process is also to require consultation with Fish and Game in the review of AoT projects. And again, Rich mentioned there's an MOU or an MOA between the various departments to facilitate that. And I think another important piece to recognize here is that DES itself has no authority to either permit or prohibit the act of take. In fact, the Endangered Species Conservation Act specifically says that any attempt by any other provision of law or rule to prohibit or permit the act of take that's contrary to what the Fish and Game Department has said would be void. And that's in 212A8. Now, I want to touch base on this Supreme Court case that happened last year, or was resolved last year at least. And that's the appeal of Suzanne Fournier et al. It was, as Rich mentioned, an appeal of a permit that was issued by DES. And specific issue that was raised was the DES's application of this rule, 1503.19H. And as Rich pointed out, at the time of that case, the rule stated that projects had to be designed in a manner that will not result in adverse impacts to T&E species. And what the Supreme Court determined in an unpublished opinion was that the DES's implementation of that rule did not comply with the plain language of the rule itself. And in other words, they found that DES was using a standard of minimizing the impacts to T&E species instead of a standard of designing in a manner that will not result in adverse impacts. And that resulted in essentially telling the department that if their rule was going to say no adverse impacts, that's what they had to regulate to. And that precipitated the rule changes that Rich discussed a minute ago. What is important to understand for the current process is that the Supreme Court's decision did not restrict in any way what standards DES can impose going forward. The court did not prescribe a specific standard that was required. It rather determined that if you promulgate a rule, you have to follow the plain language of that rule. It also did not interpret the language in RSA 212A9 that says the jeopardizing continued existence standard that's set out. So we don't yet have any guidance specifically from the court on what that standard means. And that gets back to where we can go from here. As Rich said, the current rule has moved from the no adverse impact standard to reflect the statutory language of not jeopardizing continued existence. And that's the standard that's required. But DES does have some discretion here in terms of rulemaking. DES can adopt a rule as long as it's consistent with the statutory standard of jeopardizing continued existence. It could be more specific, it could be more restrictive perhaps, but it can't be less restrictive than the statutory language. So right now, the statutory language is part of the rule. What we're going through in the stakeholder process is looking at where there are places we can improve the rule, either through an additional standard or more specificity. And there's, the point I'm trying to make is it's important is there is some leeway there. We don't have to stick to just those words in 212A9. We can interpret that language in a way that we feel is as protective or more protective for TD species. So as we have this discussion and the ongoing process that the department is going through, that gives us the framework that we're working within. And really the key thing is the 212A9 language of not jeopardizing community existence as a baseline under which any rule has to be compliant with that language. So with that, I will turn it over to the folks at Fish and Game. I believe Mike Marchand is going to be next to discuss the way that they have been implementing these AoT permit reviews and what other factors they're considering when looking at these issues. Thank you.
Great, thank you. Good afternoon, Tom. You can hand it over to Melissa while I introduce myself. So good afternoon, I'm Mike Marchand. I'm supervisor of the Non-Game and Endangered Wildlife Program at New Hampshire Fish and Game. I've been with the department for about 17 years now, most of which has been working as a wildlife biologist in the program, working on a variety of different issues, different species. As part of my previous role, which has now been filled by Melissa Doporowski, who will present next, I supervised our one full-time environmental review biologist and participated in reviews myself. So very, very familiar with kind of how the process has worked over the years. So today I'm looking forward to continuing this conversation about protections for threatened and endangered wildlife and how those protections intersect with the permitting process at DES. I greatly appreciate everyone's interest and participation today, as well as into the future, and hope to have a positive and productive dialogue regarding these issues. I'll hand it over to Melissa now, who will give a much more detailed presentation of Fish and Game's involvement in the permit process. Thank you.
Thanks, Mike. Can everybody see my screen?
Yes. Yep.
Okay, perfect. So as Mike mentioned, I'm Melissa Doborowski. I'm a certified wildlife biologist here at New Hampshire Fish and Game. I manage reptiles, amphibians, freshwater mussels, and beetles in the state, as well as manage the environmental review program here. Today, today we are here to provide a brief overview of New Hampshire Fish and Game's environmental review program to help you gain a little understanding of how we look at a proposed project, consider how those actions may potentially impact an endangered, threatened, or other rare species. We're going to talk a little bit about the review process and provide some examples of conservation measures that may be provided during an environmental review. So expand upon what Ridge and Chris talked about just earlier. We're also going to touch upon some of the challenges in the review process or in the recommendations that we provide, such as species-specific considerations, which are not a one-size-fits-all approach, timing considerations, and staffing constraints, for example. But before I get into the environmental review program, I'm actually going to take a few minutes to provide an introduction to our program, which is the Non-Game and Endangered Wildlife Program, who we are, what we do within the New Hampshire Fish and Game Department. So as Chris mentioned, in 1979, the New Hampshire Endangered Species Conservation Act was adopted. This was a way to provide protection as necessary to maintain and enhance numbers of those wildlife species who are determined to be threatened or endangered species within the state, including those that are already federally listed threatened or endangered species. It took a little while out of the Endangered Species Conservation Act, but the Non-Game and Endangered Wildlife Program was established in 1988, mainly to coordinate the protection efforts, management, and monitoring of the state's non-game wildlife species. So essentially what's not hunted or fished or trapped. So in numbers, there's an estimated 570 wildlife species or so in the state of New Hampshire. Approximately 100 of them are considered game species. The remaining 470 species are actually non-game species. And this number doesn't include the thousands of invertebrates such as insects or arachnids that also fall under the purview of our program. We started out in 1988 with 1 full-time staff person. Today we've grown to a whopping 7 full-time staff. We're a program within the New Hampshire Fish and Game Department. However, our program does not receive funding from fishing and hunting fees. We are actually funded by a variety of sources that include private donations, federal funds, state matching grants, news plate dollars. Most of our funding is dedicated funding, meaning that it's funding that needs to be used for a specific purpose. So if we have a research project, for example, on Blanding's turtle research, that money needs to be used for that purpose only. So a little bit more about what our program does. We focus our efforts on conservation planning. We conduct research on threatened and endangered species and manage species populations and habitat. We work with private landowners and land managers, providing them with tools to manage their properties with threatened and endangered species in mind. We provide education to the public on threatened and endangered species and their habitats in a variety of different formats through our website, webpage resources, brochures, public meetings, in classroom settings, and through professional conferences. We also coordinate the development and implementation of the State Wildlife Action Plan, which can be found on our website. That is a document that contains information on our current 169 species of greatest conservation need identified in the state. That includes threatened and endangered species, as well as species of special concern, and 27 habitats that support these wildlife species. This document actually guides most of the conservation actions that we do, but also provides conservation actions that anybody can implement within the state to help New Hampshire achieve conservation goals. And most of our work that we do with partners such as other states, federal government, local governments, universities, volunteers, non-government organizations, etc. Our program works closely with the New Hampshire Natural Heritage Bureau, which is out of the Department of Natural and Cultural Resources. They maintain the NHB database that contains the records of rare plants, exemplary natural plant communities, and protected wildlife. NHB has the authority over the plants and natural communities, while New Hampshire Fish and Game has authority over the wildlife species. But we work collaboratively on the maintenance of this database. And of course, some of the work that we do in the non-game program is through our environmental review program, which is the focus of our talk today. Out of our current staff, we have 1 full-time staff dedicated to this work, and program oversight and management, which is about half a full-time staff person's time, which is myself. But as I mentioned, I also do other work within the program as well. Currently, we are actually operating at about 2 full-time staff people, maybe even a little bit more. That includes the time that we're working with DES on developing the new AoT rule process. So I won't spend too much time on this, as Chris actually did an excellent job providing this overview. But what bears weight on the conversations we have today is, excuse me, a jump back, thank you, is the Endangered Species Conservation Act of 1979. This guides the work that we do within the non-game program, including how we approach environmental review. And like I said, Chris actually did an excellent job talking about the provisions of 212A, which include prohibited acts and definitions within other statutes that we have in Fish and Game that provide definitions of those prohibitions, such as the action of take. As of 2017, the most recent update of our threatened and endangered species list, there are 30 species listed. These are wildlife species listed within the state as endangered, and 21 species listed as threatened. This includes those species that are already that are federally listed as well. In addition, New Hampshire Fish and Game has identified 62 species of special concern and 169 species of greatest conservation need, as I mentioned earlier. And the 169 species, like I said, it does include threatened, endangered, and species of special concern. So this is what Ridge mentioned earlier, and I'm actually only going to touch on this a little bit because it is very important to the environmental review process. But I will mention that this is actually the NHB data check tool, so the Natural Heritage data check tool that's available on the website. This is managed by NHB, so I'm taking these slides off of their website, but again, it's important to our process and it feeds into the work that we do here at New Hampshire and Fish and Game. So I'm going to spend just a couple minutes talking about it. And as I mentioned earlier, the Natural Heritage Bureau manages all the plant information in the state, including rare plant communities. New Hampshire Fish and Game manages all the state wildlife rare species data for the NHB database through an interagency contract. All information relating to the protected wildlife records that are provided by New Hampshire Fish and Game to the NHB. And these are all documented, verified occurrences of tracked wildlife species. Landowners or landowner representatives can request this information through the NHB's online data check tool application, which through this application you can enter in, or you would enter in your contact information, a project description, applicable permits to your proposed project. This right here is a screenshot of what that looks like, where you would click off what permits apply to your proposed project or which permits may be applicable to your proposed project. And I just want to point out if the screen looks a little different to some of those who are attending today's meeting. Today, the NHB is in the middle of, or actually towards the end of updating their database data check tool online. And so this is actually a screenshot of what the new system is going to look like very, very soon. So just to provide you an example of what that submittal information looks like and what information you would get from that system, you would draw or upload a GIS shapefile of the location of your project area, so your project boundary. The database data check tool would then evaluate that area and the surrounding area around your project area for records of tracked species, and you would get a result like this. So this is an example of a no known records. It would say right in the bottom right hand of the screen, there's no known records in the vicinity of the area you mapped, and we'll offer you an official letter that states that very thing that you could put in with your project information that's valid from one day for a period of 1 year from the date of your inquiry. That letter looks a lot like this. It has your project information on it, your contact information, your project description that you provided, a map of the project boundary that you drew, because it's very specific to the area that you've defined in your submittal process, and provides you with a unique NHB file identification number, which starts out with NHB, the year that your submittal or your application was submitted, and then a unique number that is unique to your project alone. This letter identifies two things. It first says that the database has been checked for records of rare species, including wildlife and plant species, and there are currently no records found. But it also states that the negative result doesn't mean that those species or other species, that tracked species aren't within your area. It's just that our current data does not indicate that. So either we haven't done a research there, we haven't received verified documentation of a species on that property, but it does not mean that that species may or may not exist at that site. Another quick example, and this is a potential impacts project boundary. And I do want to say, for the purposes of this presentation, I randomly drew polygons for examples only. These do not represent current projects, past projects. They're probably not even accurate to parcel lines. They were just areas I identified on a map for display purposes only. And so this is an example of a project boundary that I drew that came up with, there are no NHB records in the vicinity of the area that you mapped. I'm sorry, there are NHB records in the vicinity of the area that you mapped. gives you your project area. In order to receive that information, there is a $25 fee set in rule. That's through the Department of Natural and Cultural Resources. $60 per hour for linear projects greater than 1 mile. So that fee does change depending on the type of project. That payment is required to be paid to the NHB program in order to receive your letter. And here's an example of what that letter looks like. So these are confidential letters. These are specific to the proposed project and the project boundary that was provided during the application data check application process. The letter includes both animal and or plant records that may have been found in your project vicinity, and includes contact information for NHB staff or New Hampshire Fish and Game staff to further coordinate on those species listed here. So in this example, there was New England cottontails in and around this project area. There's a note that says to contact Fish and Game Department, and there's a contact for Fish and Game Department. Again, if this letter included plant species, it would have a note from the NHB staff themselves with that contact information, giving you further instruction of what to do regarding that plant record that came up. So I kind of consider that, or we kind of consider that like a pre-environmental review process. That's something that should be done. We recommend that database data check results request is submitted very early in project planning. It helps you identify what you may or may need to consider in your project planning. And it's kind of a precursor to what is really our environmental review process. So that jumps into where we may need to coordinate with you on a project. So what I'm going to do is provide you with a general overview first of what that looks like. So you've received your NHB data check results letter. The next step is to engage directly with New Hampshire Fish and Game environmental review process and staff. And again, just to remind you, if there's, or to point out, if there's rare plant or plant communities, that coordination would occur with NHB through their process. So in the general review process, again, I'm just going to point out, this is a general review process. So this is how we would approach pretty much all projects that we get through our environmental review process. There are going to be differences that will or have occurred as a result of this new AoT permit rule, excuse me, that was adopted back in June, that I'm going to touch on and show where those differences occur. But right now, I'm just going to provide you the general overview of how we approach projects. And this includes projects such as like wetland permit projects. It's also important, I do want to make a point to say this process is dynamic. So although I'm laying out like a review process, the way it occurs can change depending on the type of project that we're working with, the size of a project, the complexity of a project. And honestly, over time, our process does change. So as our program changes, as permitting requirements and needs change, this process is not a static process by any means. We have adapted and changed over time. And I am assuming it will continue to evolve over time. So you've received your NHB data check results letter. Your letter may say no records in the database, which in the general process means you're no longer required to coordinate, or you have no further coordination with Fish and Game that's necessary for that project. Or you may receive a letter that says there are wildlife records in the project area. And going back and referencing the letter I previously showed, it will mention and indicate there that you need to coordinate with Fish and Game and give you contact information for that. So your next step is to contact Fish and Game and request coordination. This is typically done via email, sometimes by phone, but via email is usually the easiest way to do that, because often there's additional information that's necessary to continue that coordination process. And I'm going to show you a few examples of what that is. And these are things you can provide early up in your initial request for coordination, or an individual's initial request for coordination. And that could include more detailed project plans, site or engineer plans, site photos, any surveys that have been completed that relate to wildlife, such as wetland delineations, vernal pool assessments, and discussion over design modifications. So this could include conservation measures that have already been included in or incorporated in the design that the applicant has taken upon themselves. Once New Hampshire Fish and Game has received and reviewed all the conservation, or I'm sorry, all the information that the applicant can provide, we would then provide conservation measures and coordinate with the applicant or consultant in the incorporation of those conservation measures in their design plans. This can occur concurrently during review. Again, this is a very dynamic process. Often this can be over several different communications. Some of these conservation measure designs, just to give you an example, is one that we request often whenever there's a threatened endangered species is wildlife-friendly erosion control mesh. This is mesh that traditional mesh that's plastic has been shown over and over again to be often fatal to certain wildlife species. And so there's certain adaptations you can make, certain products that you can buy that are friendlier to these animals. Project communication regarding threatened and endangered species. So whatever species could or potentially be found in the area, we provide you identification for that species, contacts of Fish and Game if you make those observations. We ask that this information be provided to site construction personnel, operators. Some individuals even leave it there well after a project is done, so that if there's a building coming up, there's still information there that those species are seen at the site to continue to coordinate with Fish and Game. This often gets incorporated into the engineer plans. Other conservation measures could be avoiding wetlands or stream crossings. And if they need to be crossed, design crossings for aquatic organism passage. And as I mentioned earlier, New Hampshire Fish and Game does provide and review those projects that are required to go through wetlands permitting. Catch basin considerations. We do not want catch basins to become pitfalls for animals to get stuck in. So we make recommendations on grate sizes, or we make recommendations that no sump should be included in catch basins, or curbing considerations, such as slope curbing so the animals can get off of a roadway quicker. And buffers and setbacks, maintaining riparian buffers, vegetation buffers, setbacks between certain features on the landscape that are important to certain species, or to maintain corridors or moving corridors between sensitive species or sensitive landscape areas. So if you have complex vernal pools, for example, on a project site, maintaining connectivity between those features. Maintaining open space areas within sites is another example. This is often done for community developments, which we would make recommendations to set aside a certain area of acreage that would have a conservation restriction or a conservation easement in place. Typically, we prefer permanent conservation easements, and we often ask that, or we do ask that these include, that these include and specify the intentions of the conservation restriction or easement. So, example, it would say that it's for the preservation of threatened and endangered species. And there could be strict limitations for use. So if there is going to be tree removal done, for example, it would only be for maintaining habitat on that property for that particular species. And other examples include timing restrictions of a project activity, such as when ground disturbance can occur due to a particular species vulnerability, say a nesting season, avoiding ground disturbance during a nesting season. Or it could even warrant and we could request focused species surveys, such as a grassland birds survey. So now that we've received the additional information, we've provided conservation measures and coordinated with the applicant or consultant in the incorporation of those conservation measures in design. Again, as I mentioned, this is completed through email communication between departments. From there, the DES, AoT, would coordinate with New Hampshire Fish and Game and reach out to us to verify that New Hampshire Fish and Game recommendations, conservation measures have been incorporated into project design as we've recommended, and they would take that into consideration during their permit decision process. General overview, and considering some of the changes that we've adopted or currently practicing that are under development that we're here to talk about today for the new AoT rule. And so looking back, you've done an NHB data check results letter. This is still very important, and we would still consider any species identified on that letter that they would need to be considered during consultation with Fish and Game. Those records come up because they are in the area and they likely are utilizing that project area. However, in addition to wildlife species identified in the results letter, the project area needs to be considered for the potential presence of any other endangered or threatened species. This would be completed in essentially a two-part process, which would be like a desktop analysis, which you would use your data check results letter, but also use other resources such as the Wildlife Action Plan and other online resources, natural resource inventory information to identify any potential for other threatened endangered wildlife species to utilize that same area. And then a site visit. So that would verify whatever you determined through your desktop analysis. So if you saw that there was a stream running through your property on an aerial, you would need to go out and verify the quality of that stream or the quality of the habitat of that site and assess truly if there's a potential for a good habitat to exist there. And just to point out that assessment goes beyond the project boundary. Animals do not acknowledge project boundaries. And so when we look at a project site, we look at the area around, we looked at the project area, but we also look at the area surrounding that because that animal utilizes the entire landscape. And so how would they potentially use that particular site in the context of the landscape? The assessment needs to be completed by a qualified wildlife biologist, as Ridge touched on earlier. And the assessment should include information that already is actually part of our consultation process. So there's a wetland delineation, vernal pool, inventory information, site project boundaries, surrounding land use, any considerations or design modifications adopted. And the assessment would ideally include information or determination by the consultant if after that review, they have concluded that the project may result in an impact to a threatened or endangered species. So looking at a general approach, the next step would be to contact New Hampshire Fish and Game and request coordination. So this is very similar to, again, the general process, the current process that we do for other projects as well, except now we're reviewing this more expanded assessment of the project area. The same process would happen. We would discuss, review your assessment. We may have additional questions or request additional information or clarity on something. We would then go to reviewing your conservation measures proposed or identify additional recommended conservation measures and coordinate with the applicant in the incorporation of those conservation measures in the design. The New Hampshire Fish and Game may also request specific surveys to further refine conservation measures and inform permitting. Again, a lot of this is already in our general process and has already been as part of our general process. The big change here that's being, I guess, adapted under this new rule is expanding beyond the records that are found in the NHB data check results letter and doing a more thorough assessment of the site and surrounding area for those niche species that are identified in an NHB letter, as well as those that could potentially be utilizing the area. And then, again, once this coordination is complete, DES and New Hampshire Fish and Game would coordinate during the permit approval process that DES does. So future considerations, challenges, and opportunities. So challenges with this approach, and actually challenges to our general approach, is we want to emphasize there's not a one-size-fits-all approach. Species needs and habitat uses vary considerably, projects vary considerably. There's a lot of different variables from project to project. And so it is difficult to come up with a standard process that's going to be applicable to every project. Timing considerations for surveys, vernal pool inventories, for example, need to occur during the spring of the year. If we were to ask for certain snake surveys to look for den or hibernation sites, those need to be conducted during certain times of the year. And some surveys actually could require multiple years to gain any level of understanding of a particular area's use by a species. Some species are also easy to detect. So grassland bird survey, for example. Others are very cryptic, such as the eastern hognose snakes. Non-game staffing constraints. As I mentioned earlier, we have limited staff reviewing these projects, and we do not receive funding from DES application fees or NHP fees to support staff funding. So that is a constraint that we work under, and it is difficult sometimes to get reviews completed in a quick manner. And again, you have to consider some of the timing constraints of some of that additional information and coordination that needs to occur. Opportunities that could come out of this process is to provide more clarity or expectation of the environmental review process and conservation measures that may come out of environmental review. And environmentally friendlier projects with conservation measures that result in enhanced species protection. So the non-game program, obviously our goal is to protect and manage and enhance these populations of those species that are considered threatened or endangered in our state. And how we can work with proposers, developers, other agencies to make sure that anything going forward does not impact those species, but may even end up benefiting them in the long run is definitely a goal for us. So with that, I'm actually done with my presentation. I'll turn it over to our next topic of discussion.
Mary Ann, I think that's you. Are you all good?
All right, do you see the right screen? The correct screen?
No.
You don't? How's that? Is that correct? You don't see it?
We're not seeing a presentation.
Oh, okay. Um, yeah. All right. All right. Can you see it now?
Now we can see it. Thanks.
Okay, sorry. Thank you. Can you hear me too? Okay. My name's Mary Ann Sultan. I'm the Assistant Bureau Administrator for the DES Wetlands Bureau. I've worked at DES Wetlands Bureau in various roles, from working as an intern inspecting wetland complaints to serving as a primary contact on the DES Wetlands role. Today, I'll provide a brief overview of how the Wetlands Program addresses potential fish and wildlife impact through its permitting standards. Here's an outline of what I'll be covering today. I'll be looking at the definitions, the avoidance, minimization, mitigation sequence, standard conditions, functional assessments, avoidance and minimization BMPs and permitting standards, and compensatory mitigation. The wetland statute, RSA 42A1, finding a public purpose, provides that it's in the public good to protect and preserve waters and wetlands from unregulated alteration because of the important functions they provide. Fish and wildlife habitat are seen here in RSA 42A1. Is unregulated alteration will adversely affect areas of sources of nutrients for finfish, crustacea, shellfish, and fish of significant value, fish and wildlife of significant value, to destroy or damage habitats and reproduction areas for plants, fish, and wildlife of importance. In the wetland rules today are some key definitions that I'll review with you. First is avoidance, which is the key definition that is a cornerstone to the DES wetlands review process. This is also based on Federal Army Corps and EPA wetland permitting rules. As you see, avoidance is defined as not impacting jurisdictional areas if there is a practicable alternative to the proposed project that would have less impact on the aquatic ecosystem, so long as that alternative does not have other significant adverse environmental consequences. Minimization, also defined, means using minimization measures that remain after all practicable measures have been taken into account. So there's a three-step process that's followed through the wetlands program: avoidance, minimization, and mitigation. Excuse me. This three-step process is the one that matches the U.S. Army Corps of Engineers EPA wetlands review process. The definitions are found here. Like the Army Corps General Permit, the Department of Environmental Services Wetlands Rules also contain general conditions. These general conditions establish standard conditions that apply to all projects, dredging and filling in wetlands and surface waters. Three key standard conditions that I'll cover briefly today are water protection of water quality, protection of fish and breeding areas, and that's also found in the Army Corps. The same language is found in the Army Corps' general conditions, and protection of rare, threatened, endangered species and critical habitats. Here are a few illustrations of what happens when water quality standards and GMPs are not met. This has a big impact to humans and to fish and wildlife. As mentioned by Melissa earlier, there is coordination for wildlife-friendly erosion controls, and there are certain standards and criteria that are established in the DES wetlands rules related to that in terms of water quality. You can see when there is erosion control blankets, protected species or habitat, a priority resource area, which includes protected species or wetland habitat areas, and when Fish and Game or the Natural Heritage Bureau requests that. The second standard condition that parallels the Corps General Permit condition is to ensure the method and manner in which the work is done to minimize impacts to fish and wildlife. As you know, from discharge into surface waters, the timing of your project can have a big impact on how that might impact fish or wildlife. And these are important considerations in the design of a project. A third standard condition requires that no activity may jeopardize the continued existence of protected species or habitats. As already mentioned by several presenters today, this mirrors the language from RSA 212A. It also referenced the Federal Endangered Species Act and the New Hampshire Native Plant Protection Act. As I've already mentioned, the core standard that guides the wetlands permitting is set out in the Wetlands Statute, RSA 42A1. The Wetlands Statute also identifies 12 primary wetland functions. Two of these do reference fish and wildlife habitat, and I note them here: wetland-dependent wildlife habitat and fish and aquatic wildlife habitat. When reviewing a wetland application, a core consideration is wetland function. So when you're looking at this in terms of your design, as a developer, as an applicant, a consultant. These are key features in determining the criteria location of a project that to ensure it's cited in a sensitive manner, considering impact to aquatic wetland resource functions. And this outlines basically the rule that's found today. The DES has worked with program partners and the New England Interstate to develop a wetland BMP manual that provides an overview of the avoidance and minimization technique. This wetlands BMP provides graphic examples and illustrations, project by project, chapter by chapter, on how these techniques can be achieved. These are examples of some of the techniques that are employed through this manual, looking at the layouts, the design, how they can be narrowed or limited, how work can be scheduled, and how alternatives can be displayed. I'm providing a few examples from the BMP just for your consideration. First one is an example of an original design that DES received for a single-family driveway. You see, original proposal proposed 4 impacts, 4 crossings for wetlands and streams. The revised and originally approved and the revised and approved driveway permit that DES issued reduced and minimized the impact to result in 1 crossing and a DES permit. The second example shows a proposed subdivision. Here you see proposed subdivision with a cul-de-sac located in a vernal pool complex. In order to achieve the avoidance and minimization measures, the cul-de-sac was pulled back away from and out of the vernal pool complex to achieve avoidance and minimization. The applicant is required to demonstrate that no practical alternative with less adverse impact on the area environments under DES jurisdiction is achieved. This BMP provides a useful guide in how that can be done. Now I'll review briefly some of the other permitting standards. This is number 1. These are for minor and major projects. Second one focuses on marshes and wildlife of significant value. It's required a demonstration of how that avoidance and minimization is met in those sensitive areas. Another key permitting standard is related to fish and wildlife is the requirement that a project maintain hydrologic connections between adjacent wetlands or stream systems. As already mentioned by Melissa earlier from Fish and Game, a proper design for stream crossing will include aquatic organism passage. That's a key feature that will allow connectivity between these systems. Other standards are set out in the rules for various areas, some of them more directly related to fish and wildlife than others, such as exemplary natural communities, vernal pools, wetland systems of high ecologic integrity that are known to provide high wildlife habitat. Where avoidance and minimization cannot be met under the standards, then mitigation may be required. There's certain thresholds that are established for when mitigation is required. For example, if the project's proposing to impact over 10,000 square feet, if it's a tidal impact, or a stream impact of over 200 linear feet. Of relevance today is if there's a permanent impact to a protected species or habitat, that is considered a priority resource area, and that would require mitigation. Looking at mitigation process, there's key steps in the review sequence. The first and most important step is to participate in a pre-application meeting. At this meeting, DES is present, Fish and Game, NHB can be present, and all the state and federal partners, along with the developer, the consultants, and all to review the proposed project and explore alternatives and explain what is needed to get to the end result. The applicant must first look at whether there's permittee responsible mitigation on site, if that's practicable. If that step is not achievable, next is to look for local mitigation options. when a conservation commission has developed a list. 4 is to, if neither of those other 2 options are available, the applicant can look to paying an in-fee payment into the Aquatic Resource Mitigation Fund or the ARM Fund to offset impacts from the project. The ARM Fund has been used by many applicants and has been an excellent option to fulfilling the goals of the project while offsetting impacts resulting from the project to resource areas. Where an applicant has difficulty finding good local mitigation options, they can pay into the ARM Fund. Payments are made for wetland and stream acts for state and federal permits, and they're pooled by 9 watersheds, as you can see from the state map here. And then the money is distributed to those same watersheds through a competitive grant process. The New Hampshire Wetlands Bureau, DES Wetlands Bureau, oversees the ARM Fund. And the Wetlands Bureau the DES does assume responsibility over those projects and administration as well. Just for the conversation here today, here's some keys to a competitive conservation project. It's one that prioritizes locations to meet multiple criteria, including protecting key functions, as we've already explained how significant that is in the permitting process, looking at fish and wildlife habitat, water quality, flood storage, looking at maintaining wildlife habitat and connectivity connections to high wildlife action plan areas and locations of threatened and endangered species and exemplary natural communities, looking at restoration opportunities as well. Here's a summary of projects funded through the ARM Fund that provided preservation and restoration for high wildlife habitat. Shows an excellent example of how mitigation compensation can be achieved through the ARM Fund. Another ARM funded project in Exeter illustrates how the project protected 3 rare turtle species, protected high water supply land, increased connectivity to other protected lands, and to the Lamprey River water system. Consideration of fish and wildlife habitat has been an important part of wetland permitting standards, technical review, and mitigation. This is a good example of how we've worked with our state and federal partners to balance environmental protection with economic development. I'm happy to answer any questions at the appropriate time. Thank you.
Thank you, Marianne. This is Ridgemark, and thank you to all who presented. A lot of information there, but I think it's important to have that background as we move forward. What I'd like to do now is go through the questions we received during those presentations, and then we can take a break. And what I'm going to try to do is we're going to take them in order, and we will read the questions since not the participating audience, I don't believe, can see the questions. So looking at timestamps, the first question I received was for the emergency rule and those after, why the rush? I'm assuming that's pertaining to why did we feel we had to adopt an emergency rule and subsequently the current rule? Well, the reason for that is, one, the emergency rule is department in discussions with Fish and Game, we just did not feel comfortable that we could move forward after the Supreme Court ruling with strict interpretation of no adverse. So it was a department decision to implement another rule, and we needed that in a rather quick time frame. Otherwise, our whole permitting program would have had to come to a halt. So, and then for the emergency rule, if that same question was like, why the rush with replacing that, is those by statute, I believe it's statute, if not rule, are only they're only applicable for a short time. I believe it's 6 months maximum. So I hope that answers that question. The next question, I believe panelists can see these. I'm going to ask Chris Aslin if he could answer. There's a couple of questions here regarding 212A and 212A3.
Sure, Rich. So the question, and like Rich said, there's a couple that are related, but the first one was to explain how, I guess, the relationship between the standard of not jeopardize a continued existence in 212A9 that applies to state agencies, including DES, and the standard in 212A3 that speaks to maintaining and enhancing the numbers of T&E species. And I think the high-level answer is, well, that's what the legislature said. So there's two different standards in two different places in the statute. But the enhance and maintain provision is more of an aspirational finding by the legislature. It's in the purpose, or rather in the finding and declaration section of the statute. And it says that the legislature finds and declares that species should be protected as necessary to maintain and enhance their numbers. That language uses the word should instead of shall, so it's not a mandate under the statute. It's just sort of the goal of that legislative enactment for the Endangered Conservation Species Act. Backwards. In 212A9, the legislature imposed a separate standard for state agencies when they're taking action. So I can't tell you why those two standards are different. That was the legislature's discretion. But in 212A9, it's a shall, and it applies to state agency actions. That's the continued existence language. The two are different. They apply in different contexts. And as I said, the enhance and maintain is not a mandate per se, but a aspirational, or at least a goal of the program. I think there's a second question that was related to that. Hopefully that covers.
Thank you, Chris. And I did have another one here, and I'm asking Tom Taggart to send me, hopefully he has it through chat. There was one from a Michael Redding that appears to have been cut off. So we'll try to get back to that one. The next question was, can the wording be changed for all inquiries, even for homeowners, and especially when information in the database is not found, requiring an on-site study? And it finishes with, instead of saying this does not mean. I'm not quite sure, but I'm thinking that based on the timestamp that came in during Melissa's presentation, and if Melissa has anything to add, she can pipe in. One of our changes was if their information in the database is not found, we are now requiring an on-site survey/study. So, Melissa, do you have anything to add to that?
I also was the question. I guess I interpreted that it was meaning the wording possibly on the letters that get created out of the NHB data check tool. And if that's the case, that's something that, we could, somebody could, if there was a suggested language for that, or they could provide a more expanded upon question, that would be something I would need to discuss with NHB to make those changes.
Okay.
Or to see if those changes are possible. That's how I'm interpreting that. It has to do with the NHB data check results letters, and that language often can be adjusted a little bit, but it's not a program that Fish and Game manages, a database that Fish and Game manages, so that would have to be in consultation with.
Okay, thank you, Melissa. And we can certainly, during the discussion portion, expand upon that as necessary. The next question was, has the Supreme Court's decision changed the standard that Fish and Game uses to review AoT projects?
Yeah, Ridge, I can jump on that one. This is Chris. I would say the answer is both yes and no. The Supreme Court didn't require a different standard to be applied, but as a result of the Supreme Court case, as Ridge said, the department has changed the rule, and the rule is what establishes the standard that Fish and Game applies in reviewing AoT projects. So it has changed since that Supreme Court decision from the no adverse impact standard that was the previous rule to the current rule, which uses the statutory language of not jeopardize the continued existence.
Okay, thank you, Chris. Next question pertains to connected landscapes. The statement is connected landscapes are more resilient. So how does this apply to the fragmentation caused by AoT projects, less resiliency? I guess what I would offer there is that's part of the purpose of the review. We recognize that projects can cause fragmentation, but there's land, private ownership, rights. We're trying to work within the limits of what we can do to limit impacts and take into consideration such impacts. It doesn't certainly give us the authority to deny projects solely based on potential fragmentation. I don't know if Fish and Game would want to add anything to that. And we could talk during discussion a little bit more. The next question, and this also was pertaining to the emergency rule. How many of your permits for AoT deal with a positive T&E species? Would your entire permitting process really have ground to a halt if you took more time on the initial rulemaking? First part of that question, it is about 35% of our projects have records of T&E species, and that was just based on NHB. So I guess I'd have to say definition of ground to a halt, no, we would not have completely come to a halt, but that's a significant quantity of projects that as we go through this process is probably of a year duration, considering we started it back in December of last year and where we are today. So the decision was made that we needed to do something to allow it to move forward. Are there any plans for more funding for Fish and Game to increase their review capacity? I'll let Fish and Game handle that one.
I'll jump in. This is Mike. You know, there aren't any specific plans that I'm aware of. We wanted to just bring that up. Obviously, we do everything we can within our capacity, but moving forward, we just want to identify that as a limitation for people to be aware of as we have this conversation, and certainly open to ideas and suggestions as we move forward here.
Okay, thanks, Mike. And I suppose we could pass the virtual hat as well for donations. I believe a question from Mr. Redding. I was able to get it through chat. The word jeopardize seems to cast a broad brush interpretation from a legal perspective and can play out from a design perspective to prevent development. How does the department see the interpretation of this term, and can it be legally interpreted to allow for removal of trees or any vegetation, as vegetation is a key component for T&E habitat and its protection from predators? So, and when I see from a legal perspective, I immediately want to turn to Chris Aslin. From my perspective, I'll just quickly add that we have not considered tree clearing, if that's what you were asking, necessarily. Well, we don't have jurisdiction over tree clearing. It's land disturbance. So Chris, do you have anything to add?
Well, I think that not too much, but under the statutory scheme here, the jeopardize the continued existence language refers to agency action. And that language, I believe, comes from federal standards. It's the only place it appears in the Endangered Species Conservation Act. And it's something that's subject to interpretation by the department and ultimately by Fish and Game, since it's their statute. I don't believe it's ever been interpreted to prohibit any vegetation clearing, even in the federal regime. But it does, the 212A9 does speak to critical habitat, which again is not well defined in the statute, but there are provisions that allow the director of Fish and Game to designate critical habitat. And if that were done in a particular site, then there could be a place where if trees were deemed part of a critical habitat for a teeny species, they might not be able to be cleared. But I don't know if Fish and Game has anything further to say on that, but that's my best answer for that question.
Well, I would say the other circumstance where kind of tree removal would certainly come in is if we knew or suspected that it might result in a take or a direct impact to a species. It may or may not be under the purview of AoT under that circumstance. But if it did, then that might be something we look at in terms of, obviously, it would be something we looked at in terms of species impacts.
Okay, thanks, Mike. The next question, why don't local conservation commissions have more input or authority on AoT approvals? Legitimate question. We take comments from them. I think this is something we could explore more in the discussion and as we move forward. And frankly, we take comments from all town officials. So I think we'd want to expand upon what is exactly meant by input/authority. Next question was, what is the timeline for replacing the rule? The hopes are that we'll be able to at least start the rulemaking process in front of the Joint Legislative Committee for Administrative Rules sometime in the spring of next year. So that means moving forward with these type public input sessions and then developing the rule. And then we'd have to have public hearings, and then we would submit, or excuse me, public hearings are part of the beginning part of the process to submittal to the Joint Legislative Committee. The next question was, if the NHB letter states, although there was an NHB record present in the vicinity, we do not expect that it will be impacted by the project, do we still need to go through the additional steps of reviewing other references and performing a site visit? The answer to that is, with the rule adopted June 2nd, the answer is yes. And the reason for that is, as I had said, and I think maybe Fish and Game as well, is that record database is not necessarily has coverage over the full state.
And Rich, if it's okay, if I may add, that language, so this is again specific to an AoT permit application individual. That is, again, that response is only to any species that may be on that NHB record data check results letter. So we are still currently, what we're doing is if there's a species on there that based on the project description and the project boundary that's identified, if we know that there are some cases, they're not common, but there are some cases where we already can determine that the species might not be impacted, we can make that comment. But again, that's only specific to what is listed on the NHB data check results letter. And so as part of the new AoT rule process, as Rich just mentioned, that doesn't include the potential for any other species to be potentially utilizing that site. That review and assessment still needs to be completed as part of this process.
Okay, thank you, Melissa. The next question was, please define wildlife biologist. There is no licensing in New Hampshire continuing education. That is another part of our current rule that we certainly expect and need to expand through this process. I hope that answers the question. We agree. We need further definition. So people know that question came in at 2:30 and I have 2:39. So trying to catch up with these questions so we can then open it up to input. Although this is helpful as well, but I think some people may want to expand upon just questions. Next one was, why does Fish and Game not have any rules on this issue? I would defer on that to Mike or Melissa.
Well, it's something that we'll be looking at moving forward, and really that's the purpose of today is looking at where we go from here and what the vision is moving forward. What worked in the past, and that was the process, and that worked for us for a while, and it's clear that that may not work in the future, and we need to kind of figure out what's moving forward, what's going to work. And so that's, I guess, what I would focus on here is obviously, we do have some rules, but they're not pertaining to this specific issue. So, where I see this is defining the problem and, being visionary and where do we want to go from here? And then collectively we work together to figure out what's the best way to accomplish that. So I guess that's what I would, maybe after break, we could focus some time on that.
And I would just jump in to say, it's a valid question, but we're trying in this process to focus on the DES AoT rules. And so though somewhere down the line, we may need to implement something on the Fish and Game side to make that process work, but we're really hoping to get input on how the AoT rules can be developed, not Fish and Game rules. That might be for another day.
Well, I'm going to step in. This is Tom O'Donovan, the Water Division Director, and expand on both those comments. This rulemaking purpose is for both, for expansion of AoT and development of Fish and Game rules in the broader context. The timing of it, exactly as Chris said, is going to stretch out over time. But this effort is focused on the comprehensive role that we play across the board for T&E species.
Okay, thank you all. The next question, which is somewhat related to that, should we look for an application fee for Fish and Game to help staffing and to expedite the process? Valid question. I think we'll have more to discuss as we move forward with this. Also related, have you considered other monetary mitigation options for the AoT process besides the ARM fund for when wetlands are not directly impacted by the activity that needs to be mitigated? If I understand that correctly, the answer would be that is open for discussion, and the thought I can share from just thinking about it myself and talking with the team here is we would, if not directly have something linked to the ARM fund, it would be similar, but it would also allow for those monies to be more defined for habitat, which sometimes I'm getting out of my area of expertise, but also does include wetlands jurisdictional area and the associated or adjacent landscape. But yes, we are looking at monetary mitigation that is framed in the ARM fund method, if you will, but not necessarily directly into the ARM fund. And there may be statutory changes that would be required. Next question was, what geographic area shall be applied to the consideration of jeopardize, and will the Fish and Game Executive Director ever designate critical habitat before or during an AoT permit review? The first part, I think that's a question that is we're thinking of this process. I don't think we're prepared right now to define what that geographic area is. And as Melissa in her presentation indicated, this is not a one size fits all and that could be species dependent. So something that will be part of further discussion. As to the critical habitat portion of the question, I would have to once again defer to Fish and Game.
Yeah, and obviously, we can't answer that specifically. What I will say is we have, many of you know, we have a new director, and we're bringing him up to speed on what's going on here in this meeting today, and we'll continue those conversations as we move forward.
Okay, thank you, Mike. And next question, what would need to change to provide a portion of AoT permit funds to be used for Fish and Game review process? Generally, or specifically, I believe that would require a statutory change, certainly for a fee increase to help support. If that was the identified mechanism, our fees are set by statute right now. So we would need to have some legislative support. And let's see, I thought we were at the last question. I apologize, now my cursor moved. How many applications does Fish and Game anticipate that they will receive per year? How will the timeline for project review be Fish and Game affected? And should we expect 3 to 4 weeks for initial review by Fish and Game? I'll give my opinion on that first. Fish and Game can certainly jump in. Right now, our current application load is about 200 applications a year. So with the current rule, that has involvement with Fish and Game right out of the gate. We're going through a rules process. Things could change, whether we define which type of projects would have to go through a more rigorous review or not, would have an effect on how many applications would be coordinated with Fish and Game. And as to the timeline, that's a big question, because as Melissa indicated, species dependent, there could be some projects that require more detailed or season dependent surveys. So these are things that would have to be worked out. Certainly, we're trying to right now educate the applicant and consultant community that this should be an initial step of their project design and project consideration, well before even that they may even apply for an AoT permit. If you know you have a project, or we're suggesting, start the conversations early, because this is a type of aspect of development that does not lend itself necessarily for a 3 or 4 week review period, perhaps. I don't know whether Fish and Game would like to add to that.
Well, I would just add that although Ridge identified about 200 projects for AoT, and that's the focus here today, our staff is involved in permitting for the other aspects of DES, the wetland side as well, which number a lot more. I don't have the number in front of me, but there's a lot more than 200 on that side. So that's contributes to the overall capacity, is the other permitting in addition to the AoT. So it's not just the 200. So I thought I would just mention that.
Okay, thanks, Mike. And the next question is, have any of the 35% of AoT permits over the previous few years been denied because of impacts to T&E species? I would say there have been no denials. I would have to look at our database if there's been any projects where the applicant chose to not move forward, but we have not had any denials. With that said, we've had many projects where, we're working with Fish and Game, and the projects have been modified from when they were initially submitted. Is there approximate turnaround time of review of the wildlife biologist reports by Fish and Game? We're just into this, having become effective June 22nd. I would have to defer to Fish and Game whether they could give any input on that from the limited number of reports they've received to date.
Yeah, currently to date, I've only received a handful of the assessments. And again, the assessment process, the development of what that assessment looks like is currently under development. And we've been working and I've been talking individually with consultants on what level of details may be included in that. So we're actually just now starting to review what those assessments look like. Our hope is once we get a template designed, as you know, that is part of this, is under development as part of this process, we get a layout outline and further define and provide that to applicants, what information we're looking for to be more precise or concise, at least in the information that they provide us, that'll help us review projects much faster. But there's going to be a definite learning curve, and it's going to be slow, honestly, to begin with, as we're working through developing this process and still trying to process applications that are coming in. And you know, again, this process is going to be changing over time. So there's going to be a period where this is going to be in flux, and it could change often, you know, from project to project and how we're doing this.
Okay, thanks, Melissa. And the last question, the wildlife biologist site study is above and beyond what is required by wetlands permitting, where you have more T&E habitats in federal permitting. How did the court case require this site study? Certainly others could jump in, but the court case did not require this site study. That came about through the rulemaking process that we undertook after the emergency rule, which resulted in what we, the rule that became effective June 2nd. And as I said earlier, we had many comments during that process, and one of them, or some of them, were related to feeling we did not have enough information for making our decisions. So it was in the rule, it went through the rules process, it had public hearings, and it was adopted. Now, certainly, we're here today, we're looking at a new rule, and that could be something for further discussion. Does anyone else have anything to add to that? If not, I have 2:51 time-wise. This has been very helpful. I want to leave some time for people to have a more open discussion, if you will, instead of being limited to quick questions. So I would say let's try to come back at, we'll open this up for discussion at 3 o'clock and we'll resume then. Thank you, everyone. Okay, everyone. Oops. I didn't have my mic on. Sorry about that. I have 3 o'clock. I see some of our panel is back. We're going to get started to listen to more of our participants through the raise hand. I'm sorry, I'm just trying to get my screen so I can see them. But what I want to say up front is I think that was a very important and useful first couple hours. I hope our presentations gave you a good idea of, background on the AoT program, what Fish and Game does, and the statutory authorities that govern how these programs operate. What I really want to say for this next hour, when we hear from you, is we'd like to hear your ideas. You have a sense of how we've been operating, how we're operating under the current rule. We really want to hear your ideas and not necessarily have a back and forth and answers of questions. Certainly, if we see that we need to add some clarification, we can do that. But we're looking for ideas where you think you saw how Wetlands has implemented an avoidance, minimization, and mitigation approach. You've had a lot of questions that I think are pertaining to expressing ideas, and maybe if they could be framed that way, that the department should look at this, or the department should consider this. That would be very helpful for us as we move forward on further rule development. So with that said, and I am unfortunately raised hands. I'm just checking to make sure they're not time stamped, but is Tom Taggart back? Because I believe he's the one who controls it.
Yes, Rich, I'm here.
Okay.
You're correct. They are not time stamped.
Okay. I have as taking them in order. Kim Wood had her hand raised. Can you unmute her?
Yep. Give me 1 sec. All right, Kim, you are unmuted now.
Oh, hi, can you hear me all right?
Yep.
Yes, we can.
Oh, thank you very much for this discussion forum. I really appreciate it. I think that the on-site reviews are really important, and I think that they should remain a requirement. The other part of my question here, or request, is I'm the person who asked about the wording on the letters that go out when no data is found in the database. My impression from what I heard was that if no data is found, there's like a note saying that it doesn't mean that no wildlife of concern exists there, and maybe like a suggestion. I'm not sure if I understood that correctly, but if I did, I was just wondering if the wording on that letter could be changed to be more forceful and to require an on-site study whether or not data is found in the database.
Okay, thank you, Kim. As I said, we're taking notes, and just quick clarification. The current rule requires a survey/study at all projects that are applying for an AoT permit. The next hand raised was Jim O'Brien.
Hi, good afternoon. My name is Jim O'Brien, and I am the Director of External Affairs at the Nature Conservancy here in New Hampshire. I want to thank everybody for taking the time and putting this stakeholder session together, and especially the presentations and the Q&A. I thought that was really well done. Thank you for all your answers. I guess I just have 2 points that I'd like to make, and I guess the first one is, I think I understand and can appreciate that this is an AoT permitting rulemaking process, and that is governed by DES. But when I read the new rule, you know, a lot of the details and decision making is left up to the executive director of the Department of Fish and Game. And so I had asked a question about the Fish and Game rules. And so it just feels that if Fish and Game doesn't have any rules, but yet DES is delegating a whole bunch of, maybe not decision making, but at least guidance and advice from an agency, that agency should probably begin to develop what they mean by some of the definitions like critical habitat. And so anyway, so I just hope that Fish and Game, if the rules are going to proceed as they're sort of drafted now, that Fish and Game enters into a rulemaking process, because I don't think DES can solve the challenges here by themselves, especially if they're relying on the expertise of Fish and Game to advise them. And then, you know, to the second point is I just think as these rules are developed that the standard of avoid and minimize and mitigate be something that the agencies look at for a standard to apply to a lot of these projects. And so I know it's worked in wetlands, and I know it's a standard that the federal government uses and other states use, and it feels like that could work here. I think our concern is that the mitigate piece doesn't become the de facto step forward for projects. That there's a real focus on avoidance and minimization as a standard, and then whatever the mitigation piece is an actual mitigation piece, so that it's not just something going into the ARM fund. But it is actually mitigation that will impact the resource that is being impacted specifically for TNE species. And that may look a lot different than the ARM fund, but you know, it's important that the mitigation has a direct impact on the resource that is being impacted by the development project. But thank you. You know, I'm looking forward to the next stakeholder session in October, and thanks for listening.
Thank you, Jim. Next hand raised was Suzanne Fournier.
Real quick, Rich, before I mute Suzanne, I just want to remind everyone that the session is still being recorded. And after we unmute you to ask your question or make your comment, please put down your hand unless you still have a comment to make. Thank you.
Good afternoon.
Suzanne, you are unmuted.
Yes, good afternoon. This is Suzanne Fournier in Milford, and here are my comments. So New Hampshire is right now at a turning point. We can either turn in the direction of TNE protection in order to maintain and increase their population sizes, or we can turn the other way, leading to more common species becoming endangered. I'm going to quote from Chapter 4, page 38 of the state's Wildlife Action Plan. Quote, "At the current rate of protection and development, many more species will become rare, and several rare species are likely to be extirpated from the state," unquote. Is that what we want? Okay, so what is the Wildlife Action Plan anyway? And why does it matter? Well, it is the blueprint for conserving species of greatest conservation need, you know, TNE especially, and their habitats in New Hampshire. This is a requirement of the National Advisory Acceptance Team at the federal level there. Isn't the Wildlife Action Plan extremely important to follow? I suggest, and here's a suggestion, a practical suggestion for DES and Fish and Game, I suggest we look at the Wildlife Action Plan, all of it, the maps, everything, for the standard that DES and other agencies should follow. The standard would be to recognize the threats. They're all defined in the Wildlife Action Plan. The threats posed by the project to each TNE species and habitat as described in the Wildlife Action Plan, and neutralize the threats, not the TNE. Don't harm the TNE, neutralize the threats. Okay, so I refer you to the Wildlife Action Plan, Chapter 5, page 27, and it actually seeks to modify 212A to provide more comprehensive habitat protection for TNE, not less. But DES with this mitigation program, in other words, you can harm the species in their habitat. DES would change RSA 212A instead to provide less protection. Wow. Okay. So, and also the changes that would allow minimize and mitigate, they would have to be made to 212A through the legislature. It's not in there now. And this less protection is contrary to the Wildlife Action Plan, and I would believe would be proven illegal eventually. I have two more quick comments. The current rule since June 2nd that says do not jeopardize the species actually applies, and it should be saying so in the rule, but it doesn't, at this location. And that was made clear by attorney for DES, Gretchen Hamill, before the Joint Legislative Committee on Administrative Rules. She was asked by the attorney for JLCAR, what's the geography? What's the location? At this location. Not just around New Hampshire, at this location. Okay, the last point, I want you to imagine a project that has both a wetlands impact, large enough that it requires the mitigation into the ARM fund, a payment into that fund. And then it also has an impact to T&E that you're proposing could be mitigated potentially by a similar program, a similar T&E wildlife mitigation fund. Wow. Okay. And tell me how you're abiding by the Wildlife Action Plan that is the blueprint for conserving species. Okay, that's where you need to head, both of you, DES and Fish and Game. Thank you. I think my time is up.
Thank you, Suzanne. Next, would like to hear from Sarah Doucette.
Give me 1 second. I'm trying to find Sarah in my list here. Here we go. Sarah, you are unmuted.
Thank you. I'm Sarah Doucette. I live in Whitefield. I apologize for being new to this conversation today, but I'm grateful to hear it's underway. I work with neighbors in northern New Hampshire to protect a particular wetlands area that's been under the threat of development that we deem highly damaging since 2008. Historically, my neighbors and I have been disappointed that there seems to be little opportunity in existing statutes to protect this area that is classified as prime wildlife habitat. That is a little in terms of fish and game protections. I believe there would be lots of encouragement here in the North Country from groups with some hundreds of supporters that I work with to make New Hampshire's known habitats and migration corridors well protected from damaging development right alongside the production of threatened and endangered species. So it's heartening to hear Tom Donovan's comments that this is a combined initiative that you're working on with both DES and Fish and Game. And I would also second Jim O'Brien's comments that mitigation is the least appealing means to address habitat degradation, and that mitigation, if needed, should apply directly to the area that's being impacted. So thank you, and I look forward to the rest of this process.
Ridge, if you just said something, we didn't hear you.
Can you hear me?
Now we can.
Okay, I apologize. Next up, I'd like to hear from Susan Arnold.
Susan, you are unmuted.
Thanks. Yes, I'm Susan Arnold with the Appalachian Mountain Club here in New Hampshire. And I do want to also echo my colleague Jim's thanks for this opportunity to be educated. It's been very informative, and also the opportunity to participate. So thank you very much for that. Again, I also want to underscore some points that others have been making about the rubric of avoid, minimize, and mitigate as a framework, but it's a framework that really needs to be buttressed by scientific standards and the use of science. And I feel like in the current rule, there is an awful lot of ambiguity and potential subjectivity in the decision-making process. And I think that creates a lot of uncertainty both in the public as to how the rule will be applied, and also potentially for those who are applying for permits. I think certainty works for all of us in that regard. So I would really argue spelling out the sideboards and more clearly the standards that will be used in this process. And finally, just wanting to be clear that I, again, really agree that mitigation is the third in the list and is not the optimal way to go. And if it is going to be mitigation, it must have a nexus with the resource that is being impacted. And that should be also very clear. But also that the third option of mitigation is not simply providing a pathway to yes for a permit. And that's where we need to get back to the kinds of more clear and stringent scientific foundations for the decision-making process. Thanks again for the opportunity, and I look forward to continuing to participate.
Thank you, Susan. Next, I'd like to hear from Barbara Richter.
Okay, I think I was just unmuted. All right, well, thank you for hosting this session today. I think it's really been informative, and I appreciate the work that you're doing. I know it's a lot to pull together, but and I certainly understand that each of these projects are different, and it can be very hard to kind of nail down specifics and rules when you're looking at project review. But I think that if you want to ensure consistency and ensure specific conservation measures are followed, that you really have to nail some of that down in rules. And I think a lot of that would be on the Fish and Game side. I certainly, have a great deal of respect and trust in what Fish and Game's been doing. So I know that they, have that kind of in their head already. So how to put it down in rules so that everybody else, including applicants, have a better idea of what the process is, I think would be helpful for everybody. And I also think that the Wildlife Action Plan should clearly be part of that review process because, as it was pointed out by a few other attendees, it's really an important document for New Hampshire, and it really does lay out some good plans for protecting our threatened and endangered species. So we might as well start with a document that's really solid and work from there. So anyway, I think everybody's on the right track, and if we are going to consider mitigation as part of this, I think it should be a last resort. But if mitigation is going to be part of this process, it certainly needs to be consistent. And part of that is having a criteria that's clear for the applicant as well as those who are reviewing. So yeah, I'm pretty much echoing a lot of the statements we've just heard, but thank you again for this opportunity.
Thank you, Barbara. And before I call on Tom, you can unmute Gary Abbott, but I'll just say I see after Gary just 3 more hands raised. So for those of you who are thinking of, giving us some input, we'd certainly appreciate it. Gary Abbott would be next.
Thank you very much, Rich. Hopefully everybody can hear me. I'd like to personally thank everybody that's on this panel or group on this web. It's very rare to have both DES, Fish and Game, and the Attorney General's office on the same opportunity to give input. I appreciate that. I want to start by, I did talk to the Director of Fish and Game in June of 2019, before the court case, we were seeing, I represent Gary Abbott Associated General Contractors. We were seeing permits being held up that were going through the DES process that would get to Fish and Game, and there were no rules for the applicant's permit. So I was expressing concern with the Fish and Game director that we needed a process even before the court. So there needs to be a court so it's predictable for people that go through this process with a AoT permit. Now, the court case highlighted for me is that we need to make sure the terminology used between DES, Fish and Game, and in the statutes is consistent to what we're trying to achieve. And I'm glad Christopher was on this panel, because I think the terminology is what creates the lawsuits, and it creates people not understanding exactly what they need to do in order to get a permit. The other issue is that I supported the temporary rules that included this study of the proposed project site that's in the June rules. But I have to tell you, there's a lot of redevelopment, alteration of terrain permits. There are other city projects that I'm not so sure a wildlife study is necessary. So there needs to be in the next rules a clarification of the scope of those rules and when it applies. The NHB data check has been what people go to. And I have heard people say it's inaccurate or not enough information. I don't think it should all be on the burden of the applicant. I do think the state agencies have some role to make sure the NHB data check or other mapping for the public, as well as people that apply for permits, that there's a good tool. I hate to see the shift of all studies being shifted to applicants. I would be remiss if I don't conclude with one thing for Ridge. I would love to see in this new rulemaking the redevelopment project rules that we have discussed over the years. I would like to interject that that's a very important part of the AoT rules. And since we have had changes in stormwater and the other issues that come along with that, I would make a plug, even though this was focused on the Fish and Game, I would push for that as well to be included in this rulemaking process. But I want to say that we do need rules for both that work hand in hand so the applicant understands from the very beginning of a project what they need to do and what is most likely going to be the results. And so I think education and I think having a clear guideline is going to be really important. And I would end my comments there, and thanks, Ridge, for the opportunity and those on the panel.
Thank you, Gary. Next, we have Joshua Reap. Sorry if I mispronounced that.
No, that is exactly how you pronounce it. So I'm Joshua Reap. I'm the president of Associated Builders and Contractors. And kind of to parallel what my counterpart Gary from AGC had said is for us, perhaps one of the biggest things is when the rules are in place to consider the amount of time that it takes and educating more on the process involved. A clear guideline on the AoT process would be welcome. And not only that, it would help with the development, but ensuring that it's met with an equal balance that cohabitate with T&E and as well as the need for human development here in the state. And one other thing I wanted to say too was just in general, the new rule has really not been in effect for more than just realistically a few weeks at this point. It seemed prudent to see how it really works before we go changing it too far, I think. And just looking at other things in general, some sort of uniform guidance as to the mitigation measures from Fish and Game would be helpful with respect to designing projects. Again, I think that kind of goes back to helping to educate upfront and with some of the expectations. And that'll also go to help with pre-planning for projects to help ensure the continuing existence of these species. And another thing too, when it relates to the timeline and the length of investigation is some states, when they open up processes like this that we have seen and our association's experience is delay after delay for appeals or an indefinite amount of time that may come with when a permit may be applied. Now, it's not an issue I think that we've had much here in New Hampshire, but as we discuss these new rulemaking, I think it does bear to mind to think that when we do AoT permits, that having some sort of decision or assurances that we can have a decision made by or a plan approved or needing modification by a certain period of time would be welcomed, especially when we have a challenge here in New Hampshire where, you know, we want to, again, cohabitate appropriately with the T&E species that we do have, but at the same time reflect the reality that we have a housing crunch here in this state, and there's a drastic need for affordable housing for New Hampshire Granite State residents here. So with that, I say thank you, and we look forward to the next session in October and continuing to be a partner in these collaborative conversations. So thank you.
Thank you, Joshua. And next I have Zachary Boyajian.
Zachary, you are unmuted. All right, Zachary, perhaps we'll come back to you in a little bit.
Okay, well, this might be challenging, Tom. The next one is a call-in user. You see that starts with call-in user 27.
Mm-hmm.
Okay.
So this would be for the person with the phone number who that begins with 731.
That's correct.
Number that starts with 731.
Correct.
You are now unmuted.
Hi, this is Jennifer McCourt with McCourt Engineering Associates. I'm a private consultant. I guess my biggest concern is that, you know, these rules have just come into place and there's projects that have been in the pipeline for months now, if not a year. And, you know, to be hit with having to do this wildlife study and not having any rules or regulations or know who is a certified or who is an acceptable wildlife biologist for Fish and Game is really causing financial distress in the building community, and a lot of them are for housing that's desperately needed in the in New Hampshire. I don't know if there's a way, but it would be great if there was a way to push off the wildlife study until there were rules in place so that people knew and there was a process that was put in place that had actual timelines to it so that developers could plan on it and be able to do it. It's just, you know, if these things have only been in place for such a short period of time and you've got your whole site developed and everything else and getting, and I fully understand that Fish and Game is understaffed in many, many ways, but just getting a phone call back or an email back takes quite a bit of time. And to know what's going on and, you know, even getting a list of who is an acceptable wildlife biologist so you can hire them to actually do this study because you've already gone through the NHB process and you've gone through the IPAC process. You've dealt with, you know, federal agencies in Fish and Game, and all of a sudden now this is coming up, and it's really putting a strain on the developing community. Thank you, and thank you all for doing this. And sorry I didn't chime in earlier when the rules were going in, but here I am now. Thank you.
Thank you, Jennifer. The one thing I can offer there, and I'm certainly not committing anyone to a specific timeline, but we're certainly aware, because I'm sure it's more than just Jennifer's projects, of the new rule and the lack of definition. Now that we've had this first session under our belt, the hopes are we can put a little more time on some guidance that we have been working on to address some of Jennifer's questions about qualified personnel, time frames, and the hopes are that that will be able to be released in the very near future. Next up, I have Kristen Murphy.
I think that's me being unmuted. This is Kristen Murphy. I do want to thank you all for this opportunity. This has been a really great workshop. I wanted to express my support for the model that's developed through DES of avoidance, then minimization, then mitigation. I think that's a tested model, and I think this AoT process should continue following that. And I would also really like the rules to assess consideration of cumulative impacts. So not just for individual projects, but a consideration for projects that have been permitted through this process in the past as well. And the final one, I think that obviously there's a huge lack of funding and support for both the Heritage Bureau and Fish and Game's non-game program. And I'd love to see some, I don't know what it would be, but some magic way to get additional funding there. And I think that would help through the permitting process, ensure things move smoothly.
Thank you, Kristen. And next I have Carol Foss.
Hello, Carol, you have been unmuted.
Thank you. Carol Foss with New Hampshire Audubon. I also thank everyone involved, both the presenters and the participants, for an excellent discussion this afternoon. I would like to express my support for the avoid, minimize, mitigate approach, echoing Jim O'Brien's emphasis on stressing the avoid and minimize first. I'm thinking that it could be helpful to everyone in the next work session if we could have some information from the Wetlands program on what proportion of projects are addressed through avoid, what proportion through minimization, and what proportion through mitigation, just so we can all get a sense of how frequently or infrequently things do go to the mitigation extreme, shall we say. And having some examples of, as you did today, a few examples of avoid and minimize. I think that could be helpful in moving things forward. And when it comes to mitigate, you really have to have flexibility, because different species require very different mitigation approaches. I appreciate the desire for uniform guidance, but I think where this needs to go is to strive for the maximum consistency, but also to provide flexibility. And that's going to be a balancing act as we move forward. Thank you.
Thank you, Carol. I was Could we try, is Zachary Boyajian still available, or maybe he's left the meeting? Are you able to unmute him, Tom?
Yes, Zachary has been unmuted because he is there.
Okay, thank you.
I want to take a quick chance here to remind other attendees to put their hands down if their comments have been addressed or entered, unless they have additional things to add.
Well, that's a very good point. I'll give everyone a minute because there are still hands raised, but they've already been called on, and I can't tell whether someone has had would like a second opportunity. Now I'm.
Ridge,
Go ahead,
just
Tom.
a heads up. I got a message here from Zachary saying that he's calling in separately on his phone. He might have been having audio trouble through his computer.
Okay. Okay, well, I think just to make sure people, since we do have the time, if they did want a second opportunity, I see that Barbara Richter has her hand up. Do you have a, could you unmute her and see if she's got an additional comment?
Barbara, you are unmuted if you wanted to add something else.
Oh, yeah, I think I just didn't put my hand down. I did have a chance to comment earlier. So thank you for checking in, but that I can put my hand down now. Thanks.
Okay, thank you, Barbara.
Sure.
Hey, Rich, can I jump in?
Sure.
I would just add, as we kind of close in on the final 20 minutes or so, I like Carol Foss's suggestion on kind of what to look for towards the next meeting. So if people have thoughts on what they would really like to see as part of the discussion for the second meeting, we'll be evaluating that and putting that together in the coming weeks. So if you have thoughts or suggestions there, I think that would be helpful as well.
Thank you, Mike. That's a great suggestion. I do see that Suzanne Fournier has her hand raised.
Yes. Hello, Suzanne Fournier again from Milford. My earlier question, one that I had typed, I don't believe was answered well or even attempted. So I had listened to Fish and Game, and it seems they issue the same types of conditions on projects regardless of the DES rule. I've not seen any changes in the types of conditions. This is since before the Supreme Court decision, after the Supreme Court decision, after June 2nd, current rule. I don't see any changes in their conditions. So I wanted to ask, what standard is Fish and Game using? And I'll just make the point, are they doing direct take? They just forbid direct take, but they allow indirect take. I think they need to address what standard they are using because their conditions have been the same. So you see, there's been no change, no observed changes in standards that Fish and Game has been using based on the conditions they issue. So that's a question. And then I have one more point after if you want me to hold off on the second one. But did Fish and Game want to respond?
Yeah, I think Melissa was unmuting herself.
Yeah, I'd just like to point out what Ridge mentioned earlier is, and Ridge, please correct me if I'm wrong, but following June 2nd rule requirements, is that correct?
I'm sorry, Melissa. Hopefully it was just me.
No.
I didn't hear a thing. I heard a couple words in your maybe turning off your video will help.
Oh, I'm sorry, I got the screen froze for a minute.
There you go.
Okay. So I'm sorry, Reg, I missed your response.
My response was, we didn't hear anything you said for response.
Okay. I was just saying to Suzanne's first comment that she hasn't seen a change in standards. I'd just like to point out that to my knowledge of an application hasn't been reviewed, approved, or denied, hasn't gone through a full complete process with DES yet that applies to the new June 2nd rule. Is that correct? I think we're just now starting to review some of those that have come through that fall in.
That I'd have to check our database. We're getting into the fine detail, but we typically review in the 50-day time frame from, and that was June 2nd. So that would take us. You're correct. Well, no, that would take us to mid to end of July. So there probably have been a few.
If I could add to that, I have calculated it's about 40. There were about 40 applications since June 2nd, out of about 140 for the year so far. There's been about 40. I do understand, Melissa, that there will be the study that you will evaluate. I do understand that. I'm saying that the conditions that you have applied to all the projects, they all look the same. They're the silt fence, they're fix the culvert, it's the safe mesh, it's everything you named earlier in your presentation. Okay, so I'm just asking, what standard do you use? That no direct take, but only indirect take, silt fence causes indirect harm and such. So it just sounds like you're not saying what standard you are using. All right, thank you. And I do have one quick follow-up when you answer that, after you answer that question, and it's for Attorney Aslan. Or maybe it's for a fishing game. It should be for fishing game. Okay, maybe that was just a comment. You don't want to respond?
I don't know. Actually, I don't know quite the right way to respond to that on a standard. We don't have like necessarily a standard that we're applying, other than we're reviewing projects for teeny impacts, and conservation measures are always changing, and we're always looking at current research and current guidance that not only is applied within the state, but in other areas through research findings. And so that's an ever-changing process that we're constantly evolving through.
Yes.
And so those will always change. And so there's not going to be a drastic change in what those look like compared to what.
Okay.
Yeah, and I would just add that the rules and regulations haven't changed on the fishing games side through. Can you still hear me?
Yes, I do.
The permit, the permits are.
I think we were talking over each other. And you're frozen, so I'm going to take the floor. I mean, I was basically just saying that, during that time, the fishing game rules and regulations haven't changed. What we're trying to do is work through this process and determine how that fits into the new rules and regulations at DES. And that's, moving forward, that's kind of part of this process, figuring out the survey, as you mentioned, and then where we'll go from there. But I don't know, Melissa, if you heard that or if you were going to add anything, but I just wanted to make the clarification that it's the rules and regulations within the DES that have changed and not at Fish and Game.
Thank you. This is Suzanne again. One quick question again for Fish and Game, because I did type a question and it was not addressed correctly. It is having to do with the 212A:7. It's paragraph 2. That's the one that's the executive director of Fish and Game can issue a permit for scientific purposes or to enhance the propagation or survival of the affected species. I've always understood that to mean that a scientist can request to capture birds and do a study on them, or some mammal and do a study on them, and for the purpose of propagation of that species and their survival. Is Fish and Game using that paragraph for in the let's see, in the conditions for projects, in the review of projects, are you using that paragraph to say that somehow a project, a development project, might be enhancing the population, might be increasing their chances of survival, other than, let's say, If you require a culvert for wildlife crossing, they may not be road killed. That's not exactly the type of survival that I think is intended in this paragraph 2. So how is Fish and Game applying paragraph 2?
Chris, I can take that, or if you want to, you mentioned it in your introduction, so I didn't know if you wanted to say something. I guess I'll start and basically say, I mean, we're interested in that. There's not further rules around that standard. We're interested in that. We haven't referenced that standard specifically in referring to permit applications, but I think that's looking at that a little closer. I think is one of the areas that we could look at moving forward to see how we want to interpret that language. And I guess I would ask Chris if he had any more based on, because he had included that in his introductory presentation.
Yes, he did.
Yes, and Suzanne, that power has been utilized in some projects when project conditions that are implemented to protect T&E species, such as exclusionary fencing and then a mooring sweep or a pre-work sweep to locate T&E species and remove them from the project area. That is, as you pointed out, potentially a take under the definition of take. And there have been instances where Fish and Game has issued a scientific permit, or whatever the right term is for that permit, to allow a trained individual to do that work to remove species from the area that's been excluded for a project.
That's pretty shameful. Okay, it's pretty shameful. Thanks for explaining. It's been used already. Yeah, shameful. Thank you.
Thank you, Suzanne. I'm looking here, and the only hand raised was Zachary Boyajian, but we do have a little more time, and I did note, I just looked at the Q&A function.
Rich, before...
Sure, Tom.
Before we move on to the, there are a couple new questions in the Q&A. Zachary chatted me his phone number, and so I think I have him here as a call-in user. I'm going to try unmuting him. Zachary, are you there?
Hey, good afternoon. Can you hear me?
Yes, we can.
Excellent. Good afternoon, everybody. Yeah, that's one of the drawbacks of working on a military network. Sometimes computers don't work very well. We have to use two modes of communication. I'm Zach Boyajian. I work with the Department of Military Affairs and Veteran Services. And we not only often have to get alteration of terrain permits for a number of our construction projects, but also have a fairly robust endangered species program at a number of our sites. And so we really are trying to balance those things, and sometimes it's difficult. Consistency in the permitting process is very helpful, and we're often moving to get our alteration of terrain permits in one of the last stages of our construction cycle processes, which sometimes start 6 years in advance of us actually breaking ground. And we've often done NEPA analysis, environmental assessments, or other types of surveys on the property well in advance of us actually getting the AoT permit. And then we get to the point where we've actually gotten the funding, and we move that to a design company and ask them to start developing our alteration of terrain permit. And we start reliving the same questions we've been asking ourselves maybe once or twice or prior to that in earlier reviews. And having some consistency in when we ask those questions and address them would be helpful. I don't know how exactly that could get built into the alternation and terrain permit rules. If there's some way of taking credit for previous work would be helpful for any federal agency that might have to do that, or any agency that has some other federal nexus. The other thing that I wanted to talk about a little bit was the shift that's appeared to take place with the language change between trying to not adversely affect the species jeopardizing a species. And the thresholds for those two things are at the far ends of the spectrum of what might happen to a species. An adverse effect might be something very, very small, a small disturbance to a species as there may be, you know, foraging, for example, for a very short duration or period of time could be considered an adverse effect. On the other hand, jeopardizing continued existence of the species is a much more comprehensive level of effect that, as I said, maybe causes a population to no longer exist either in a locality or on a statewide basis, or maybe even, you know, across its entire range. And at least from the federal perspective, a jeopardy opinion is a pretty significant thing, and there are not a lot of them that happen. So there's this huge paradigm shift that's been changed in the rules, but I'm not sure that the process that's going on has changed to reflect that, or that that was really the intended consequence of changing the rules. We still seem, and Suzanne kind of talked a little bit about this, the mitigating things or conservation measures that are asked during the alteration of terrain process, like different kinds of silt fence or erosion control netting or environmental awareness to the construction workers, which are all pretty typical things we see getting proposed, really aren't addressing a jeopardy action, but are addressing these adverse effects to the species. And so I think all that really needs to be lined up, that the language in the rules really and the process that's being put in place addresses the language in the rules. I think that would be extremely helpful. There was another thing that came up, and this relates to the way the new rules apply. I think Melissa talked a little bit about it with regards to the on-site assessment, and she talked a little bit about trying to address and take into effect activities on neighboring properties. And that is certainly a good idea, but I think in some circumstances, people may be limited as to how much information they're going to be able to get on a neighboring property. In most cases, they're probably not going to be able to enter that property. And I know certainly from our perspective, as a state agency or a federal agency, if we went wandering around on other people's property, we might be brought to court. So the only thing we can really do is use existing commercial or scientific available information and maybe remote sensing kind of information. So I just would caution you to consider how and when people are really looking at you know, how species are acting on neighboring properties. Thank you.
Thank you, Zachary. Okay, at this point, seeing no further raised hands, we did get a few more questions, and I think I may have inadvertently skipped over one, but someone asked, which brings up a very good point, would it be possible to make the scripts available from the meeting today? They had some challenges with the audio. Yes, this is being recorded, so that could be made available. And I meant to mention earlier, same with the presentations for those who would like to review them in a little bit more detail. The next question was, how does this process work into the statutory timeframes set by the legislature? Well, from my perspective, that could be something that we have to address through this process. As the person asking this is aware, we do have statutory timeframes, and if whatever we come up with requires additional time, that would have to be addressed by legislative action. Excuse me. So something that will be discussed further and pan out from where we go with this with the public input. I'm not sure if I read this one. What is the timeline for getting a template for the assessments? Will this include certified wildlife biologist credential criteria? Actually, I think that was similar to the one asked by Jennifer McCourt. We are working towards getting that. We've had to focus some of our energy on pulling this together today, and my hopes are we'll be able to provide some guidance in the relatively near future. And I believe that's all I have for questions. Oh, one just popped up. Administrative question: how will these comments be used since we are not in a formal rulemaking docket here? Well, I guess that's just having to realize we've held these as a department because we value the public's input, and I frankly would treat it the same way in the sense that we're looking for ideas, and this is the beginning of the process in that we're going to have additional session, and then we go through the rules making process where the public will have additional opportunities to comment. And so we're treating these comments very seriously, I think is the point I want to make today. And that's what I have. I'll give an opportunity if anyone else wants to say anything. I would just say that we did record this. I intend to review that to make sure we didn't miss any points. I was jotting notes as quickly as I could. I heard some points about the avoidance, minimization, and mitigation as being a potential template, with a few people stressed the avoidance and minimization should come first, and then some other comments on what the mitigation could entail. So that's helpful. The other comments were on, I guess directed towards fish and game, rule development. So that was heard, and some other comments that were more on the financial, if you will. That will be part of this process as well. So if people have additional comments, you have my contact information through email. Certainly send me emails if you have additional ideas moving forward. And another question did just pop up. Could we have another meeting? Excuse me. Could we have another meeting specifically for determining the qualifications and assigning a wildlife biologist to each project? I don't necessarily see a specific meeting. That would be something in further rule development. And the next meeting is intended to start getting into more processes, hopefully having formed some idea of standard, and that may still be up for additional comment, but we're going to go back with all this information, and we'll have something to put out to the public, and also an agenda for the next meeting. So I'm not sure at this point we would specifically have a meeting, and as I spoke to earlier, we're working on some guidance on that, so that may help address that question in particular. Is there anyone else from the panel that would like to make a comment? Please unmute yourself.
I would just like to thank everybody for their participation and their interest, and I know sitting on WebEx call for 3 hours. It probably isn't your favorite thing to do on a Thursday, but I think it worked out okay, and I really appreciate all the comments. And again, if you have thoughts on the next meeting, we'll be putting that agenda together. As Rich mentioned, we're hoping to get a little bit more into the process, whereas today was more about the standard. But of course, we kind of got a little bit into the process. This meeting we'll probably get a little into the standard next meeting as well. So that's okay. But love your further input as we move forward. So thank you. You're on mute, Ridge.
Well, thank you, everyone. Like I said, we'll be moving forward. We will be publishing on our webpage the specific date of our next public input session, which will be sometime in October. And thank you very much for attending today. And I hope many, if not all of you, can join us as we move forward on this process. Enjoy your evenings. Thank you.